Good evening, everyone. I'm Ashley Winder with 92i. Thank you so much for joining us. Tonight's conversation is part of a new initiative from 92i, Campaign for 100%. Between now and Election Day, we're hosting a series of virtual events that explore how voting impacts individual lives, communities, our government, and society as a whole. Please visit 92i.org/campaign for 100% to learn more. You can sign up for additional events, check your voter registration, register to vote, and more. We're so thrilled to welcome Attorney General Eric Holder, Ben Sheehan, and Zak Malamed to our virtual 92i stage tonight to discuss the very timely topics of the Supreme Court, the Census, gerrymandering, and the Constitution. Eric Holder served as the 82nd Attorney General of the United States during the Obama administration, where he was a staunch advocate for civil rights and voting rights. AG Holder currently serves as chairman of the National Democratic Redistricting Committee. Ben Sheehan is a former executive producer at Funny or Die and the author of OMG WTF, Does the Constitution Actually Say? A non-boring guide to how our democracy is supposed to work. And OMG WTF is Gerrymandering, a journal for concerned citizens. Our moderator tonight, Zak Malamed, is the co-founder and executive director of the Next 50, where he works to make politics accessible to a new generation of donors and candidates. He previously was the founder and executive director of Student Voice, which organizes high school students to advocate for equity in education. As a community center, your participation is very important to us. Please submit your questions in the comments section of whatever platform you're viewing on. Now I'll turn it over to Attorney General Eric Holder. Thank you so much.
All right. Well, thanks, Ashley, for that a great introduction. You didn't mention my age, which is always a good point at this in my life. So good evening to everybody. We are going to have an interesting conversation, and I think it's a great time to have this conversation. I actually think that we are at an inflection point as a country. I think we have an opportunity in the election that comes up in November, and then over the next couple of years to save, renew, reinvigorate our democracy. I mean, I think it's absolutely critical that everyone gets to the polls this election, but that I think is really just the first step. We need to keep up the civic activism of the past few years and make sure that what we are experiencing now, this renewed sense of desire to be engaged, we have to make sure that's just not a moment, but actually becomes a sustained movement. There are a number of things that we're going to be talking about: court decisions, politics, the involvement of people around the country. And as I said, I think this is a really good time for us to have this conversation. I think people always say, this is an important election. I actually think that these are the most important elections of my lifetime. Obviously, with regard to the presidency and the choices that have to be made there, the choices could not be more stark. What is at stake could not be greater. But I hope people will also focus on the important down ballot races that are on the ballot as well. Much of what concerns us as people are decided at the state level. We talk about the need for criminal justice reform. If it happens, that'll happen largely in state legislatures. Protecting a woman's reproductive rights, again, that will happen mainly at the state level. Criminal justice reform. There are a whole range of things that happen at the state level. Healthcare. And so we need to focus not only on what happens with regard to the presidency, but also what's going to happen in those down ballot races as well. And I think to help us in this conversation today, I'm going to bring Ben and Zak out, and we will engage in this conversation and hopefully get people who are listening and watching to participate as well. Ben and Zak magically appear.
Well, thank you, Attorney General Holder, for joining us today. And thank you to the 92nd Street Y for hosting this really important conversation. We're having this conversation amid Supreme Court confirmation hearings, a U.S. Census that actually, I just heard as I joined this streamer, was put on hold today via court ruling. And of course, an election that's just 21 days away. It's hard to fathom, but there's a lot at stake. Over the past 36 hours or so, I actually read the Constitution for the first time that I've read it in 10 years, probably since I watched the Schoolhouse Rock video or something to that effect. And I'm sure many people who are watching today also haven't read the Constitution lately. But while not a long document, the topics of conversation on it are innumerable, and they'll definitely affect what plays out over the next 21 days and, of course, through probably the next decade. In fact, there's a whole field of law devoted toward litigating it, a branch of government devoted to interpreting it, and another branch devoted toward amending it. Today, we have the great privilege of having a conversation with Attorney General Holder and my good friend Ben Sheehan, who I believe is the premier layman's interpreter of the Constitution, to get answers to the most pressing questions that leave many of us uncertain. And I want to start today's conversation on the Supreme Court, because we're amid a Supreme Court confirmation hearing for Amy Coney Barrett. And it feels appropriate to lead off with what the Constitution says about the highest court in the land. I want to start with you, Attorney General Holder. There's a lot of conversation about whether or not it is appropriate to appoint a Supreme Court justice this close to Election Day. From John Adams rushing appointments to Abraham Lincoln holding off, there have been varying applications. What does the Constitution say about when it is appropriate to appoint a justice to the Supreme Court?
Constitution says nothing about that. This is all about customs, norms. Lincoln, I think, did it right. He had the ability to appoint somebody at the end of his first term, but decided that it would be more appropriate. It wasn't clear that Lincoln was going to win re-election, and he thought it was more appropriate to have his successor be the one, after the people had spoken as to who should be the president, to have that person actually appoint the justice. And we've never seen an appointment in the last year of a presidency this late. We've never seen a confirmation this late. And this is, I say this is about norms and customs, but this is really just about power. I mean, the way Merrick Garland was treated, that was about power. It wasn't about, customs or when things happened in the last year of a presidency. And Mitch McConnell and the Republicans are exercising the power that they have now, exercise the power that they had then with regard to Merrick Garland, and made a determination that they were going to try to keep a seat open when Merrick Garland was being considered. And now they're going to rush one to fill a seat with regard after the death of Ruth Bader Ginsburg. So, we can talk about norms, we can talk about traditions, we can talk about what the Constitution says or not says, but what we need to understand is this is about power. And I think Democrats need to understand that if Joe Biden's elected, and if there is a Democratic Senate, and if they assume that Democrats maintain the House, there's power. There's power there for the Democrats to use. And given what has happened with regard to how the Republicans have, I think, inappropriately used their power on two instances with regard to the court, Democrats need to think very seriously about how they use that power with regard to how the court has been shaped by the Republicans.
Totally. And on that point, you mentioned Mitch McConnell. Many argue that when Mitch McConnell was overseeing the confirmation hearings for Merrick Garland, he actually altered the size of the court. Ben, many on the left are discussing adding more justices to the Supreme Court should Joe Biden be elected president. What does the Constitution say about the size of the Supreme Court, and what reforms to the court could be allowed?
Sure. So it doesn't say anything about the specific size of the court. And really, in the first almost 100 years of the country, the size of the Supreme Court changed. We started with 6, and then it went down to 5, and then up to 7, and then up to 9, and then up to 10, and then back down to 9, which is what we've had since 1869. So Congress has the power to change the number of justices on the Supreme Court. And when we're having this conversation, I think it's really important to understand the original intent behind the court, but specifically with lifetime appointments. These are the people who are not directly elected by the people, but have the job of interpreting the Constitution and federal laws. And the reason, in part, that they have a lifetime appointment is so that they wouldn't be beholden to partisan whims, that they would be balanced, and that their real allegiance would be to the Constitution and the longevity of the document in the country. So when we're having this conversation and words come up like packing the courts, the intent is to have a balanced court. People who are upholding the Constitution, whose allegiance is to the Constitution, who have lifetime appointments, or really during good behavior is the technical term in the Constitution, but so that they wouldn't be, running for re-election or beholden on people to keep giving them their power. They have it for a long time. So when we have this conversation about adding justices, I think we have to have it under the guise of what is the original intent of this branch of government, and what is its function, and we have to have a conversation about how it's important to have a balanced court, so that we are putting the best people in charge of interpreting the most important document in our country.
Totally. And, on that point, the Supreme Court also affects our ability, or has ruled on our ability and the access of many in our country to vote. And so I want to pivot to voting rights, which the Supreme Court has influenced in recent years, and the former Attorney General worked to defend. Before we turn to the Attorney General, Ben, can you walk us through the significance of the 14th and 15th Amendments in the Constitution?
Sure. So the 14th and 15th Amendments came in the 5 years after the end of the Civil War. And while there's a lot in the 14th Amendment, it's 5 sections, but specifically the first 2 sections are very, very relevant to voting. So in the first section, it gives birthright citizenship to African Americans and former slaves by making people who are born in this country, although the Supreme Court would later carve out some exceptions, U.S. citizens. But in addition to equal protection of the laws at the state level, granting due process among state law and state legal process, there is the second section, which also is sort of overlooked and not discussed as much as the first section, but it had to do with voting. And what it said is that if states did not allow certain people to vote, specifically men who were 21 and older, U.S. citizens and residents of their state, then that state was penalized. And how they were penalized is that it was a decrease in the population basis for representatives in the House. And there is one small section, 3 words, where states wouldn't be penalized if that person had committed a crime. And this is one of the roots of felony disenfranchisement in our country, dating back to this sort of carve out in the Constitution. But the 15th Amendment 2 years later gave voting rights, basically protected voting rights, because it's important to understand that the Constitution doesn't proactively give voting rights to people in the United States. It protects their rights if they have them from being taken away if they're citizens in the 15th Amendment based on their race, color, and previous condition of servitude. So while these amendments moved the ball forward in terms of voting rights, or really protecting voting rights, they failed to stop, an ensuing century almost of poll taxes and literacy tests and whites-only primaries. And, I think it really gets to the fundamental point, is that the Constitution and the provisions in the Constitution, federal laws, are really only as good as the people who are enforcing them. And after 1877, really the election of 1876, where which is often referred to as the Great Betrayal, where the new president, Rutherford B. Hayes, in exchange for him taking office, because it was a very hotly contested election, it was controversy, one of the most controversial in American history. In fact, one of the 5 where the winner of the popular vote did not win the Electoral College. But the compromise was made to pull all the remaining federal troops out of the South, specifically Louisiana and South Carolina, who were there enforcing the 13th, 14th, and 15th Amendments, and other civil rights laws, the earliest civil rights laws passed by the Congress. And so what happened is then you didn't have people enforcing these laws, and you had state governments that were taken over by white supremacists, and you had, the things I mentioned earlier, poll taxes, literacy tests, whites-only primaries, and we really didn't see a huge fix on those, or at least another major advancement, until the 1964 Civil Rights Act, the 24th Amendment, also in 64, banishing poll taxes, and then the Voting Rights Act in 1965.
One thing I'd say about those amendments, Amy Coney Barrett is, an originalist, a textualist, as they call it, in the way that Justice Scalia was. And what always strikes me about that is they always want to go back to the Constitution, the 19th century, the 18th century Constitution, and look at it, make determinations about what, the way in which our nation should go, without ever looking at the civil rights, the Civil War amendments, which are as much a part of the Constitution, under the way in which the Constitution says it can be amended, as anything else. They never look through the 14th and 15th Amendment when it comes to deciding voting cases, for instance. And that's why I always think that, when you say you're an originalist, a textualist, it's more than a little disingenuous when you only focus on the earlier document without taking into account the way in which it was amended and the circumstances that led to its amendment.
Well, Attorney Holder, with that said, you had to defend voters, or work against the active attempted voter suppression through your landmark Shelby v. Holder case. And the ramifications of that has affected our electoral process since 2013, both in 2016 and could again in 2020. Can you walk us through how that case has changed the electoral landscape?
Yeah, in 2013, the Supreme Court, in what I think is among the worst decisions, I won't even say of recent past. I think history will judge that as one of the worst decisions of all time. In a 5-4 decision, essentially gutted the Voting Rights Act and essentially took away from the Justice Department the ability to do what's called preclearance in the covered states under the 1965 Voting Rights Act, which was largely, not exclusively, but largely the southern states from the Confederacy. That had a history of voting discrimination. Before any significant changes could be made to the electoral process, if that was challenged, the Justice Department would have to pre-clear and say, all right, South Carolina, you want to close polling places in a black neighborhood, you can't do that. And they either had to not do it or they could sue the federal government and try to have a judge say that what they were trying to do was appropriate. Supreme Court took that tool away from the Justice Department. And the results of taking that away were immediate, and they have been, those results have been long lasting. About 25 states almost immediately went into the field and said, wait a minute, we don't have to worry about the Justice Department anymore. They put into place these unnecessary photo ID laws, to try to stop in-person voter fraud. The Brennan Center has done a study and says, you're just as likely to cast a fraudulent in-person ballot as you are to get hit by lightning. And nevertheless, they came up with these photo ID laws, which have, and were designed to have a negative impact more on the ability, not to prevent fraud, but to have a negative ability on the people who perceived as Democrats to get to the polls. African Americans, Hispanics, poorer people, young people, try to keep them away from the polls. We've seen 1,700 polling places around the country close since 2013. Again, without the ability of the federal Justice Department to say, you shouldn't do that. And so the landscape has really been changed in the sense that a lot of the hoops that we're going to have to go through, that people around the country are going to have to go through in order to cast a ballot in 2020 is a direct result of what the Supreme Court did in 2013. Justice Ginsburg, in what I think is going to be, hopefully serve as the basis for the reversal of the Shelby County decision, or maybe it'll be it'll serve as the guide for a reconstituted Voting Rights Act if the Democrats take over the Senate, the House, and have the presidency. She said, if you're in a rainstorm and you've got an umbrella that's keeping you dry, you can't pull the umbrella away and think that you're going to stay dry. And that the Voting Rights Act was essentially the umbrella that the nation had and that people of color had to protect them from the reign of discrimination that historically had been present and is still present. She was prescient in saying that we were going to see the kinds of things that in fact we've had to deal with.
And you've swooped into action, in Wisconsin in the primaries this cycle. You were doing work to focus on these down ballot races, which you alluded to earlier. Can you speak a little bit more about how the NDRC is working to support down ballot races and the impact that'll have on the voting landscape this cycle and for the next decade?
Yeah, I'm the chairman of the National Democratic Redistricting Committee. We formed that in January of 2017, specifically to deal with the problem of gerrymandering, partisan and racial gerrymandering. We've had this in the nation almost for as long as we have been a republic. Democrats have engaged in gerrymandering as well as Republicans. And if you look, however, at what happened in 2010, 2011, with the redistricting that happened in 2011, Princeton did a study and said that the redistricting done in 2011 had more gerrymandering, historically inappropriate gerrymandering, more than you'd seen over the course of the last half century. It was that bad, and we've had to deal with that over the course of this decade. Gerrymandering puts people in these safe seats. They can do then whatever they want and don't face any negative electoral consequence. It's why you see the American people saying, at like 70, 80%, they'd like to have background checks when it comes to, the purchase of a weapon. And yet you have state legislatures all around the country where that is not put into law, and the people who don't put it into law, go against the wishes of their constituents, don't suffer any electoral consequence because they're in these gerrymandered districts. And so what we decided to do was to make sure, because we redistrict every 10 years. It'll happen again next year after the census this year. We decided, let's try to make this just fair. I don't want to gerrymander for Democrats, because I actually think if the process is fair, Democrats will do just fine. But let's just make the process a fair one. And so we have been supporting candidates, bringing lawsuits, trying to put in place these independent commissions to actually do the redistricting in 2021. And hopefully, if we do that, we would have legislatures that would act in a way that was consistent with the desires of the people, and you'd have laws that would not discriminate against people when it comes to voting. You would protect women's reproductive rights. You would probably see greater expansion of Medicaid under the Affordable Care Act. There's a whole variety of things that would happen, and I think you'd see less cynicism about government, and you'd have a better nation.
One of the most astounding things to me is that if you look at the 3 states that determined the last presidential election, or often are referenced as the states that did that, you look at Michigan, Wisconsin, Pennsylvania, all 3 have Democratic governors, but none of those states has a single legislative body that is controlled by Democrats. Yep. And that is in large part due to gerrymandering.
Yeah, I mean, if you look at what happened in Wisconsin in 2018, Democrats got 54% of the vote for both houses and have about 1/3 of the seats in those houses. And that's a direct result of the gerrymandering that was done in 2011.
Yeah, and I want to turn. You also referenced a moment ago the census and the role that the census plays in gerrymandering. We'll get to that in a moment. But Ben, gerrymandering is but a footnote in our U.S. history classes, and it's something that is very easy, or U.S. Civics classes. It's very easy for us to forget about that after we graduate from high school, college. How do you describe gerrymandering to your friends?
Well, in 2018, the organization that I started, OMG WTF, launched a line of boutique jewelry where every necklace and pin was shaped like one of the worst gerrymandered congressional districts in the United States. And we did this for real, and we made a Zales jewelry ad that got millions of views. And we used jewelry to educate people about gerrymandering. And as the entry point for that, we then explained that, this is something that happens every 10 years after the census. The idea behind redistricting is positive, and really, the roots are in the Constitution. The idea is to redraw these districts because over a 10-year period, people move out of their state, they move around within their state. So to make sure that these districts are equally sized, whether it's a state Senate district, a state representatives district, whether it's congressional districts, so that people's votes count equally in determining the representatives. But once we get into the idea that these can be manipulated, because in about 2/3 of states, the people who draw the lines draw their own district lines, so they can cheat so that they stay in power for a long time. And how they do this is a couple of ways, but primarily either by cracking, which is taking voters and drawing it so that one political party is spread across many districts, usually the minority political party. And the other way is packing, by drawing it so that one district is heavily concentrated with the minority party in the state's voters, so that the other districts go reliably for the majority party. There are other ways, even like kidnapping, where you redraw the districts and you put 2 incumbents in the same district, so they're forced to run against each other. But it's something that really it's been around, as the Attorney General said, it's been around for a very long time. The term dates back to 1812, where the districts in Massachusetts were drawn in such a way that they looked like a salamander, and the governor at the time was Elbridge Gerry, and so that's where gerrymander comes from. But this is something that is used to it is a tool of voter suppression, and it's a tool in voter suppression not in preventing people from registering or casting a ballot, but once the votes are cast, they are rendered unequal because of the way that the districts are drawn. So it is ultimately a voter suppression tactic in terms of the counting of votes, and it's something that we haven't focused on a ton because, again, it happens every 10 years. And what we saw in 2010 was using technology and these advanced map-making technology to really precisely gerrymander. So given the news about the census today and the fact that this is really our last chance in a few weeks, to elect people, we're not just voting for a president, not just voting for, Senate races, but we're voting for state legislative races. And all throughout the Constitution, state legislatures are mentioned, and they have so much power. And the fact is that in 2/3 of states, the legislatures are going to be drawing the line. So it's very important that everyone watching this knows who their state legislators are. You can go to openstates.org and just type in your address, and they'll tell you who your state representatives and state senators are. Look them up, follow them on social media, get ready to bother them in the next few weeks to make sure that when they redraw these lines next year, they're doing it fairly so that everyone in your state is equally represented.
I think Ben gave a really good explanation and definition of gerrymandering. But I think for people to understand something, and this is literally true, gerrymandering allows elected officials to pick their voters. Literally pick their voters. These are the people I want in my district, as opposed to having citizens choose who their representatives are going to be. It turns our system, on its head, and something that I'm dedicated to fighting, and we'll see how successful we are, next year.
Yeah, and it actually also leads to this aging or increasingly aging Congress, because people are able to entrench themselves in very safe districts, and it prevents a refresh and turnover of leadership in Congress, which, of course, as time goes on, we desperately need because circumstances change. One example of how the courts have even ruled against this partisan gerrymandering is in the state of North Carolina. We have all new districts this cycle, right, Attorney General?
Yeah, the Supreme Court, in another terrible decision, said you're not going to be able to bring partisan gerrymandering cases in federal courts. These are political matters and should not be decided in federal courts. You can still bring racial gerrymandering cases in the federal court system. And so now what we've had to do is to focus on the state courts using the state constitutions and say that, all right, the way in which you've drawn the lines here in North Carolina violates the North Carolina Constitution. And so now we've gotten rulings from the North Carolina state court system, a 3-judge panel there that's given us a basis to redraw the lines so far with regard to the congressional representation out of North Carolina. I suspect we'll look and see how they redistrict next year. But if it doesn't happen in a way that is consistent with that opinion, that from the North Carolina court system, we'll be back into court to challenge the way in which they potentially draw the lines with regard to the state legislature. So yeah, the battle is now, if you want to deal with partisan gerrymandering, it's going to be kind of a slog. You're going to have to go, state by state.
What's amazing to me is, 10 years ago, the last time we had the census, we didn't have a presidential election. This year we have a presidential election, a U.S. census taking place, all of these critical down ballot races taking place. But it's important to turn to the census for a moment, because today the Supreme Court ruled that the Trump administration could put a halt to the census, as I understand it. This was breaking news for me.
I've not heard this. Is that right?
Yeah.
Yeah, it happened about an hour ago.
So we got a live reaction from the former Attorney General. React to what this means. How do we address this?
Well, I have not seen the opinion. The Trump administration has been monkeying around, or trying to monkey around with the census for the better part of a year now. They tried to include a citizenship question on it, sued them, won that. Then he puts out an executive order and tries to fool around with whether or not immigrants should be counted in the census. The Constitution says every 10 years we're supposed to do a census, and it says count all the people in the country. It doesn't say count all of the citizens. And then, because of the pandemic, the Census Bureau has said, we're going to have a hard time getting enumerators, the people who actually get into the field and take census forms to people. They're going to have a hard time doing what it is that they need to do, given the pandemic, and we need extra time. And so initially the Trump administration said, okay, that's fine. I think then they realized, well, if you do that, you're likely to have a complete and accurate census, which is not consistent with what their aims are. So they went back on that and said, no, it ought to happen, take about a month and a half off the time that we originally agreed to. Again, we sued with regard to that. I don't know what the Supreme Court decision is saying here, but that's a very disheartening thing. I mean, the census is really one thing that had traditionally been kind of a nonpartisan thing. The Bush administration passed off to the Obama administration the preparation that they had done, and they had done a good job. And I think we tried to improve on what it is that they had proposed. But it was almost like a seamless handoff. And the census in 2010, I think most people would agree, not perfect, but was actually pretty good. The census in 2020, I'm really afraid, is not going to be accurate, which will have an impact on the redistricting that we do next year, but also has a negative impact on the ability of the federal government to decide where about $1 trillion in federal aid goes to the states, for schools, for roads, all kinds of federal assistance is based on an accurate census count. So this is, again, I'd have to see the opinion. I wasn't quite expecting to hear that in the middle of this conversation. That's pretty disheartening. That's pretty disheartening.
Ben, the census is about as old as our country. It is as old as our country, more or less. First census, I believe, took place about 3 years after the Constitution, our current Constitution, was enacted. Can you tell us a little bit about what the founders' idea was behind the U.S. Census?
Well, really, the census, and to the Attorney General's point, is ultimately about money and power. And in the beginning, it was really in the Constitution, it was for two purposes. It was to enumerate the population in each state, so they knew how many representatives they got in the U.S. House. And it was always also how they determined how much tax each state paid, because back in the day, it was everybody paid an equal amount. So you had to decide how many people were in each state to know how much tax a state was paying. Now we also have income tax. We have many other different types of taxes that didn't exist back then, but today it is mostly used for apportionment in the U.S. House, apportionment then in state legislatures, and also local districts also draw school board seats, and city councils have districts that they base on this information. But it's also about money, and it's about knowing how much how many people are in your state and your local community, so that when time comes, whether it's disaster relief or funding for education or a whole number of things, you are getting the amount of money that you need, and you're not getting undercounted, because the direct result of being undercounted in the census is losing political power and losing money for your state and your community. And so it's important for people to know that what the origins of it were, which were to make sure people were counted evenly so that apportionment was equal in the states or accurate in the states. But today it has huge ramifications on how much money we receive.
And again, I've not seen the opinion, but if they've said that the census counting should now stop, that is totally at odds with the professionals, the nonpartisan professionals that the Census Bureau have said, which is that we need time in order to do the physical counting, but then we also need additional time to make sure that as we review all of the material that we bring in, we can use our scientific capabilities to make sure that we are adjusting things where we didn't perhaps get as many people counted as we think there are people in a particular jurisdiction, so that they can actually deal with the statistics that have been found and then kind of perfect them. And that takes a period of time as well. And if the Supreme Court has cut off both those time periods in terms of collecting the data and then massaging the data, working with the data, that really puts at risk, the likelihood that we're going to have an accurate census. And that has huge implications for our democracy. I mean, just huge implications. This is a decision I'm going to have to read, but I suspect I'm not going to enjoy reading.
I just did a quick Google search while you were answering, and it appears that the census was halted while the appeals process plays out because of the Trump administration's challenges to that in the court system. There's a lot to unpack there, but there's also a lot to learn and read, and we're just hearing about this information in real time. And so with that, which is a lot to take in, with our limited time left, I want to be able to touch upon the presidential election. There is fear out there in America that the results of the election are going to be contested. And in order to really understand what a contested election looks like, Ben, I'd love for you to walk through what the Constitution says about how a president is even elected.
Sure. So for anyone unfamiliar with the Electoral College, it's a process that's very unique to the United States. My personal opinion is that it's a very undemocratic process, but the way that it works is that each state gets a number of electors, and those electors are equal to the number of its senators, which is always 2, plus its representatives, which varies. So the largest state, California, has 55 electoral votes. The smallest states, there are a few, like Wyoming, the smallest, get 3. But what happens is that when we're voting for president, we're really just voting for a political party's slate of electors that they have chosen. So we are not directly voting for president or vice president. And then these electors, the date where the electoral vote actually happens, because it is people casting votes, they vote for a president and for a vice president. But this year, that date is on December 14th. And then those electoral votes are going to get transferred to the seat of government, to Washington, D.C. And on January 6th at 1 p.m., the Senate president, who is also the vice president, Mike Pence, is going to oversee the process where those votes are counted in the presence of Congress. And how it happens is that if somebody gets a clear majority of electoral votes for either president or vice president, they become the president, the vice president. If those, for whatever reason, they don't get a clear majority, there's a tie, or somebody simply gets a plurality, then it kicks it to the House to decide the president in sort of a tie-breaking fashion. But what's unique about this is that each state gets 1 vote. Not each representative gets 1 vote. So California gets 1 vote, Wyoming gets 1 vote, Texas gets 1 vote, Rhode Island gets 1 vote, and you need a full majority, so 26 states to win the presidency. And then if a vice president doesn't get a majority of electoral votes, it's the Senate that decides it, and it's done by senators, not by states. So it is a clear majority of senators, so 51 are needed, and the House is choosing from the top 3, and the Senate is choosing from the top 2. So this is the process. And then the president and vice president don't actually take office until January 20th. So that's the structure, sort of in like a timeline frame of what's going to happen. But what's really fascinating about this is that it really goes back again to state legislatures, because state legislatures are the ones who have the power to decide how the electors are chosen. And since 1880, every state legislature has said that we use a popular vote in the state to determine the electors. But before that, for almost the first 100 years, at least 1 or 2 states, and sometimes more, would just choose the electors directly themselves, and people didn't get a vote in the process. And recently there was a Supreme Court decision that said that it is constitutional for states to require faithful electors. If they have laws in their state or provisions in their state constitution that say the electors have to go with the popular vote, that is constitutional. But about 1/3 of states don't mandate that electors follow the popular vote in the state. And so what's always sort of been almost just like going through the motions and a procedure, and we've never, or at least not in a long time, really since 2000 for sure. But before that, not since the 1800s, have we seen a situation where it really came down to the counting of electoral votes. But it is possible because there's a provision, a federal law, that says that establishes something called the safe harbor date. And this year, that safe harbor date is December 8th. And what it means is that if there's a controversy around the appointing of electors, so around the vote, so if there has to be a recount, there could be claims of voter fraud or vote by mail fraud or whatever it is, there's a controversy. It is possible for states to decide if they want to find a new way of appointing the electors. And as long as that law is passed and before December 8th and acted on by December 8th this year, it counts. But what it is going to come down to is each state's own laws and constitutional provisions in their state constitution for how this happens. So this is a very long way of me saying that this is an ancient, convoluted process that honestly has its roots in slavery. Because at the time, the way that electoral votes, how they're determined is based on representatives plus senators. And how were representatives determined at the outset when counting the population? Free people counted as 1. People who were serving for a fixed amount of time counted as 1. Native Americans who didn't pay taxes counted as 0, and everyone else counted as 3/5 of a person, i.e. enslaved people. So it's not an accident then that for the first 5 presidential elections, Virginia, which had the highest population of enslaved people, which meant they got electoral votes based on that, for the first 4 of our first 5 presidents were from Virginia. So we have to look really at the roots of where the Electoral College comes from, how it works. Again, pay attention to your state legislators these next few weeks, but I think it's definitely a system that is long overdue for a refresh.
So, Attorney General Holder, is it possible that state legislatures could appoint a slate of electors that don't align with that state's popular vote?
Technically, I suppose that's true technically, but that would be a usurpation of the people's power. That would be as gross an affront to American democracy as anything that we've ever seen. I would hope that the courts would be a bastion against would prevent that from happening. But it's hard to imagine that a situation like that could occur. And yet, I think that given who this president is, and the devotion, at least in some quarters in the Republican Party, to him, you got to be prepared for any possibility. And so, getting ready for court cases, people understanding the Constitution, state laws. These are all things that are going to be necessary. I'd hate to think that we get to a place where, pick a state, Wisconsin, Michigan, wherever, Pennsylvania, where the people have voted for Joe Biden, and that the state legislators, Republican state legislators, somehow decide that they're going to impanel, they're going to send send the names to the Electoral College of people who are in essence Republican electors. That if that happens, this nation is in big trouble, really big trouble.
So we don't think it's likely, but I also think it's important to point out that 10 years ago, when we had state legislature elections and the census at play, it was so important for us to invest in state legislatures at that time, because this possibility only plays out because state legislatures were won by the Republicans who won it. So that makes this election all the more important as it plays out.
We can complete a circle here. I mean, the state legislatures that potentially could do this are not the ones who will be elected in November, though they won't start serving until January. We're talking about these gerrymandered state legislatures. So you could have a situation in Wisconsin, for instance, where let's just say, again, I don't think it's going to happen, but theoretically, you could have a Republican legislature there decide to impanel a different set of electors, and these are again these Republicans who got 46% of the vote, and yet have they have 2/3 of the seats. And so they would have the capacity, the ability to do this, in spite of the fact that they don't have. It goes against, I think, the spirit of who we say we are as a nation, and is also inconsistent with the will of the people. But again, a gerrymandered legislature would have the ability to do that. One more reason why, we focus, and I understand it, on the presidency, but we as a nation have got to focus on these down ballot state races. They really, really matter.
Absolutely. There's a lot of fear still around this, and we'll turn to some positivity and aspirational ideas in a moment.
Please, give me something positive here.
Give me something positive. It's coming next, I promise. But I want to address a question from one of our attendees, Sherry Lee Leonard, who asked, what happens in the event Trump refuses to leave and declares an unconstitutional election? Is that possible? How does that happen? Ben, tell us what the Constitution says about that.
Well, the Constitution is pretty clear that the president does not have the ability to delay an election. Congress has the power to decide when the election happens. And, it's worth pointing out that as we're seeing now with different, rules around voting by mail and different days around early voting, is that states really have, the power to decide how elections happen and how they unfold. And, although Congress does have the ability to override that, around the times, places, and manner. And one way they've done that is by making Election Day the first Tuesday after the first Monday in November, all the way back in 1845. So, we haven't changed this for 175 years, but this is the power of Congress to do this. The president cannot move an election. And getting back to what I mentioned earlier, sort of the end of the Electoral College process is that, per the Constitution, on January 20th at 12 p.m., a new term begins for both the president and the vice president. And if there hasn't been a president or vice president determined by then, which could potentially happen, I don't think it will, but who knows these days, Congress has provided through a law the line of succession, and the line of succession goes as follows. It's the Speaker of the House, who would then become the president if the president and vice president have not been chosen. After that, if for some reason the House hasn't picked a speaker yet, they'll have started their term 72 hours before the counting of the electoral votes in about 2 2.5 weeks before the new term. So hopefully they've picked a speaker by then. If they haven't, then it would be the Senate President pro tempore. And then after that, it goes to the cabinet, and where every cabinet department head in order from creation. So starting from the first cabinet position, Secretary of State, all the way down to the final one, which would be Homeland Security. So they have about 18 people in line in case we don't have a president or a vice president chosen by January 20th at 12 p.m.
Well, it's interesting. I mean, Trump's would be, he'll be irrational and quite perturbed if Joe Biden wins. If Nancy Pelosi ended up being the president under that scenario, his head would explode,
It's true.
I want to encourage all the audience members to continue submitting your questions, because we'll get to more of them in a moment. But I want to pivot to a question that's a bit more perhaps aspirational. Interestingly, the rise of conservatism over the last 50 years has coincided with 50 years of no meaningful, and I use that word liberally, constitutional amendments. While the Constitution was specifically crafted to prevent dictatorial rule, let's say you were given the opportunity to make one amendment to the Constitution. What would it be? Ben, I'll start with you.
Well, I've got three, and one of them is actually already been introduced. A right to vote amendment. Dick Durbin of Illinois introduced maybe a month or two ago, a right to vote amendment, because we don't specifically have a right proactively to vote in the Constitution. We have certain voting rights protections for citizens based on things like their age, being 18 and up, their sex, their race, but we don't have a fundamental right to vote. So while I have a few amendments I like, it's very hard to amend the Constitution. That would be one I'd start with, since it's already been introduced.
Well, Ben, also, can you just give a little bit more context around the fact that, like, the 50 years going by, with the one exception in 1992, with no constitutional amendments, is fairly irregular in our country's history. Is that correct?
Well, yes. I mean, the longest gap between amendments was between the 12th and the 13th, and that was over 60 years. So, we did have an amendment in 1992. There's a very odd story, and this is something I talk about in the book. But it was because of a student at the University of Texas who was very angry about a grade that he got on a paper about an amendment that hadn't expired, and in true petty fashion started writing state legislatures around the country. And for the next decade, they started ratifying it, and then it got added to the Constitution in 1992. But going back before that, the 26th Amendment was 1971. And interestingly enough, that was also the result of young people's activism, not necessarily over a grade, but over the fact that people were being sent over to fight in a war, and they couldn't have a say in the people sending them off to fight. And the motion for this amendment started in the wake of the World War II, but it was passed, during or ratified during Vietnam. But this is it is rather unique, and I think it's because the framers, the founders, set up a difficult process to amend the Constitution. They wanted it to be changed because they gave us the ability to change it. But the way that it happens, you need 2/3 of Congress, both houses of Congress, to propose an amendment, or 2/3 of state legislatures calling a convention, which has never happened in American history. And then to ratify it, you need 3/4 of states, which is 38, and you either need conventions within the states or you need the state legislatures within the states. So you have to get 38 states ultimately to agree on ratifying the amendment. And given the partisan climate we're in, that seems like a difficult task.
A.G. Holder, what's your one amendment?
Well, I think, I like Ben's. I mean, that's something I think is extremely important, because I think that would solve an awful lot in our society. But let's say, all right, he's got his and he's making his happen. I'm going to take mine. I'd do away with the Electoral College and make the president be elected by direct popular vote of the people. He's, the president, he or she is the one person who is seen as the national leader. That's the one national office that we vote for. And, to have it go through an electoral college process where, as we've now seen, I guess, 4 or 5 times, where somebody can get fewer popular votes and still end up as president, I think that's bad. And I think it also, if you had direct elections, you would then have Republicans campaigning in New York, campaigning in California. Democrats would be campaigning in Texas, for instance, in ways that they do not now. You would truly have national elections. It means that you wouldn't be spending, inordinate amounts of time and money on these so-called battleground states. You would be going where the people are. And I think that would be, that would be a better way to do it. You also decrease the possibilities, these concerns about fraud. It's one thing to try to, throw an election in, I don't know, New Hampshire, a small state. It could be a battleground state. Do something in Wisconsin. If you can fool around with a few hundred votes, 1,000 votes, I don't know, whatever, you might be able to, rig things in that state. To try to do something on a nationwide level, to use fraudulent means to try to steal an election on a nationwide basis, I think is close to impossible. And you see in 2000, Bush won Florida by, I guess, 535 votes, something like that. So you could fool around there with 600 votes and maybe change the outcome there. But Al Gore won the popular vote, I think, by close to 2 million votes, something like that, or maybe a little less than that. And so it would have been extremely difficult to try to throw that election on a national scale. So I think for a whole bunch of reasons, doing away with the Electoral College would make a great deal of sense.
So we have this election in 21 days, and I want to address two action-oriented questions that both Sarah Fisher and Brady asked. Sarah asked, what do we do about states like Georgia where people are already waiting in lines? And Brady wants to make sure that we are asked the question, how do we ensure that every ballot is counted, even if it takes several additional days? Attorney General Holder, do you have an answer to that, especially with the work you're doing at NDRC?
Well, one of the things that we need to do is, again, focus on those down ballot races, because all of the things that are impediments now to people having adequate polling places are decided at the state level. And just because they exist that way now doesn't mean they have to exist that way forever. A new good legislature, not a gerrymandered legislature with a good governor, could change those laws, as they have done in Virginia, where they have done away with these unnecessary photo ID laws. You could have adequate numbers of polling places, electoral resources directed to places where they don't exist. I mean, you look at in Atlanta. I guess in the primary that happened, I guess 4 or 6 weeks ago, something like that, they did a study. The average white person in Atlanta and in the surrounding neighborhoods had to wait like 6 minutes in order to cast a ballot. Black folks had to wait 51 minutes, 52 minutes. And again, we're talking about basically the same city and suburban area. And that tells you a lot about the ways in which things are being done in an unfair way. And again, directly connected to the Shelby County decision, where 1,700 polling places, have been closed. And so focusing on those down ballot races, good legislature, all of that stuff could be remedied.
Do you have faith that all the votes will be counted?
Yeah, I think so. I think, it's going to be, you all are too young, but Betty Davis in All About Eve says, buckle up, it's going to be a bumpy ride. Go Google that, folks. It's a great Hollywood line. I think it's going to be a bumpy ride, but I think it's ultimately going to be fine. But I think we need to sensitize the nation. The media can play an important role in this. Sensitize the nation that we might not know who the winner is on the night of November the 3rd, or even into the early morning of November the 4th. But that's okay. If it takes 2 days, 3 days, better to get it right than to do it fast. And Trump will undoubtedly try to say, he might try to proclaim himself the winner, try to delegitimize votes that are waiting to be counted. If we steel ourselves, if we are, expecting it might take longer than simply a night, those attempts by him will fall on deaf ears. And so I think we need to, get ready for that. We understand, in the 2000 election, that election wasn't decided for 20, 25 days until the Supreme Court ruled on the voting in Florida. So this has happened in our recent past. But I do think that at the end of the day, I think the ballots will all be counted, but it's not going to be easy. I mean, they're going to be court fights. We had hanging chads in 2000. They're going to be all kinds of stuff that, lawyers for the Democrats, for the Republicans are going to be fighting about this stuff. But I think by the end of that whole process, I suspect we'll have a fair count.
Well, we're running out of time here, but I just want to recap a little bit about what we learned today. Read the Constitution. Like I did. You want to understand what's going on? Read the Constitution. It's not a long document, but it is one that is so critical to the foundations of our democracy. I encourage you to buy and read Ben Sheehan's OMG WTF does the Constitution actually say? And OMG WTF is gerrymandering. Ben, sorry, did I get that correct?
Nailed it.
Awesome. Well, there are great reads that'll help you understand what'll shape our country over the next, well, of course, 21 days, but also for the next 10 years. And I want to also thank the Attorney General for taking time today to explain what's at stake in our country, but also for the important work he's doing to make sure that we have a just and fair electoral process where everyone is counted. And I want to thank the 92nd Street Y for hosting us for this really important, timely conversation. Of course, make sure you vote. And do everything you can this cycle to make sure that your friends, your peers, your neighbors are able to vote too. But with that, thank you, Attorney General, and thank you, Ben, for joining us today. And thank you to the 92nd Street Y for hosting us. Have a good night.
Take care.